And so this was the legal landscape when the province decided to issue a multi-year forestry tenure to Weyerhaeuser on Haida Gwaii, where a third of the old-growth forests on Haida Gwaii became subject to a tree farm license, and the only consultation with the Haida was just a phone call at the last minute to say, by the way, this is going to happen. And so we went to court on, in the Haida case, and the Crown government said, well, you know, the point is we don't really have to respect the law in Delgamuukw until the First Nations proves their case in court or enters into a treaty under the BCPC. Other than that, it's just not, you know, anything we have to do. And the court said, well, actually not, and placed constraints on the Crown. Now we're beginning to get a whole articulation of Crown constraints based on the assertion of Crown sovereignty and the fact that there are two jurisdictions at play, and the Crown, the province, is constrained, and the federal government, when they make decisions contemplating an interference to Aboriginal and treaty rights. We think that in some ways the Haida case created a lot of, it was a kind of opening because it was a landmark case in a different way than Delgamuukw. It required governments now to do something different. And so the difference is that we got this whole new regime about consultation and accommodation, and we've got a lot of impact benefit agreements, and there's a lot of better prosperity based on developments which are going ahead in First Nations territories. And so you think that, well, there's the landscape. Now let's get settled and get on with the coexistence of these legal orders in a good way. Let's get on with building shared decision-making models of making decisions collaboratively. Let's get on with revenue and benefit sharing. Just what you think would naturally flow from the law that's flowing in that direction. Well, instead what you had is that the government regrouped, and they went back and they developed a new legal theory, still based on extinguishment, which they ran in the Chilcotin case. And this case is before the Supreme Court of Canada. Now it's been argued, and we're waiting for the decision. But the new legal theory, which the BC Court of Appeal accepted, is that when you get to court, because the court in Delgamuukw articulated a process for adjudicating cases that come to court involving Aboriginal title, that say that Aboriginal people have to prove their prior existence exclusively in 1846 with some continuity today, and they have to prove interference. The Crown has to prove extinguishment and justification. Under that framework, the Crown said, First Nations have to prove their title. So this is actually a big piece of the Chilcotin case where the Crown said First Nations have to prove their title. They can only prove title over exclusive areas of occupation, the Crown says. And so the Crown said, and the Court of Appeal accepted, that Aboriginal title only ever exists over these teeny small spots of land over which Aboriginal people can prove their title. And of course, I've gone to sleep with the doctrine of discovery. When you litigate, you have to know your opponent. And for 30 years, I have to say that I completely understand the doctrine of discovery. I maneuver it in my mind daily. And so when I heard the Crown say, oh, okay, First Nations have to prove it, but we don't have to do anything except lay back and wait for them not to be able to prove it, this is the doctrine of discovery speaking, and this is what was litigated in the Chilcotin case, and we're waiting for the decision of the court. And I wanted to say about the Chilcotin case, and just to kind of swing you around in this little circle that we're in right now, that what the trial judge found as a fact was that the Chilcotin had met the test to prove title to a very large area of their territory, and over other parts of their territory they had succeeded in proving rights, not title. And I wanted to just comment that even in this formulation, there is still something misguided, that if the Crown argues that if the First Nation goes to court and doesn't prove title, that the land becomes the property of the Crown and it's extinguishment by litigation. And that's kind of a new door that we've seen open up since the Chilcotin case was argued. But in any event, to return to the moment, meanwhile, while this case is before the court, the government contemplates authorizing Prosperity Mine to go ahead and to really wreck Fish Lake and to cause major environmental damage to the watershed by this mining. Now, Prosperity Mine is in the area where Aboriginal rights were determined and not title. And the Chilcotin have allied with their allies up north, and also many down south, but particularly those that are concerned with the environment. And they successfully raised before two environmental review panels, the damage which this mine will cause, and two environmental review panels have now recommended to the government that this project not go ahead. And so in a way, I have to just take my hats off to the beautiful work that the people have done in keeping and protecting prosperity against prosperity mines based on the environmental damage and the rights which the Chilcotin have been able to achieve legally. But the brood underneath it all is Enbridge. And if I could just return at this point to the West Coast Oil Ports Inquiry, where 40 years ago we stopped tanker traffic. Really, Prosperity Mine is kind of a mom and pop operation as compared to the big multinational Enbridge operation, which is threatening to build pipelines and super tanker traffic, all this oil from the tar sands, this particular kind of oil through the pipelines, and then tanker traffic out of RBC Pros. And the reason I come back to there is to make 2 points. One is to say that what happened with Prosperity Mines is that the federal government said, well, the environmental will go ahead for now. We don't know whether or not it will be for later. But they could turn around, and we expect that they will, to say that, well, the environmental review panel said that there wasn't, on balance, good reasons why Enbridge shouldn't proceed. And so I can imagine that the response from the federal government shortly will be, well, we're listening to the environmental review panel all over again, and so we're going to approve Enbridge and threaten our coasts and the communities this way. So I wanted to stop in that circle and just make 2 observations. The first is that the law, I'm going to call it Aboriginal law, which is law that is made in non-Indigenous laws and legal orders courts. This is the Crown courts. This law has done a lot, and you can see we've gone a long ways in making space for Indigenous laws and legal orders to operate, pushing back the Crown, defining Aboriginal title as having a jurisdictional and an economic component, putting constraints on the Crown. We've done a lot, but when it actually comes to putting it on the ground, the courts have not been effective. We haven't been able to achieve remedies that actually shifts the status quo sufficiently that we actually are back to the balance created by 2 laws and legal orders coexisting, 2 titles coexisting, and coexisting to the benefit of both. We're still overwhelmed by the domination of Crown governments. And so so that's the first observation, and I wanted to say about that I retired from the practice of Aboriginal law because I really wanted to move into putting Indigenous laws and legal orders on the ground. I think that that's the path that the only path that we have, not only for the benefit of these beautiful cultures which have stewarded the land under principles which are very different than what the dominant cultures have to offer, but also for the sake of this blue and splitting planet, I feel like we need to have Indigenous laws and legal orders back at play. So So I'm not trying to in any way cast I don't want to cast any kind of negativity on all the amazingly good work that Indigenous nations have taken through the courts. I'm really grateful for the work we've done and for the response the court has had. But I think the court has a limited role to play now in terms of actually standing up Indigenous laws and legal orders. We've created that space, and now Indigenous laws and legal orders need to be assisted in standing up on the ground with the capacity to protect the land and steward the land again in a way which benefits the land and also the Indigenous cultures whose lands it is. So I'm going to talk about that in a minute, and I also want to talk about a second observation, which is that while all of this has been going on domestically, internationally, Indigenous peoples have, again, thanks to the work of the late Grand Chief George Manuel, who founded the World Council of Indigenous Peoples, there's been a consolidation of thought, which is like the consolidation of thought that brought in the doctrine of discovery. But this consolidation of thought has birthed the UN Declaration on the Rights of Indigenous People. And the doctrine of discovery has been officially repudiated, and the UN Declaration on the Rights of Indigenous People brings in a completely different way of looking at Indigenous rights. It's now not a matter of, Crown dominance with the duty of consultation, or Crown dominance with a burden on their title. The UN Declaration talks about a human rights framework where Aboriginal and treaty rights are human rights, and everyone has the right to self-determination, and every people has the right to control the resources and the processes within their territory about how decisions are made. And so the principle of free, prior, and informed consent is part of the UN Declaration of Rights of Indigenous People. And so we've got a whole different worldview that's now come into place, which is part of the shift of paradigm, along with the decisions of the court. And then I want to talk last about Indigenous laws and legal orders. Having worked in the courts for a long time, I see that the courts, courts are not the only, this is just one dispute resolution mechanism. And it's based on a competitive adversarial system, which, like the early colonizers who saw the world through the lens of the social Darwinism piece and through the lens of self, the court also basically is premised on there being winners and losers. There's peoples who are right and wrong, and judgments about whether or not somebody's guilty or not guilty. It's a very individual model that continues looking at the world through the lens of self. And that's a very different way of looking at it than Indigenous laws and legal orders, where you find in the law of respect is universally applied, where we're all one, we're all seen not as individuals, but we're all connected, that divine spark that is in humans and plants and animals and in all living things, that beautiful moment of creation where we're all a part of the same, that is embedded in Indigenous laws and legal orders. So instead of seeing there being winners and losers, the ideas which come out of Indigenous laws and legal orders universally, and I'm not trying to get too general, but I did want to put my finger on this, is you keep seeing laws which tend towards peace as opposed to winners and losers in conflict, laws which tend towards installing balance rather than making privilege to some party who gets the judgment in their favor, tends towards respect and reciprocity and humility and the values and the virtues which lead to a harmonious human interaction between the humans and all other living things on the planet. Those stories that are carried forward are actually laws, although we haven't given those laws space to grow and to develop and to become part of the way this blue and spinning planet is being managed. And I wanted to go back to Enbridge and say that when this planet was forming, after the starburst and all of these rocks were forming into our planet, and our planet was forming into our little Milky Way universe, and we started to orbit around the sun, and a piece of the Earth blew off and became the moon and started to orbit around the Earth, and then these water asteroids blew into the Earth, and you know, of all the most amazing thing, it was just enough water. Like Mars had too little water and it all evaporated, but on Earth, the force of gravity kept all this water moving, and then the Earth's rotation with the moon formed the tides, and so all of this pull and push of the Earth to the moon and all of this water that came to be, that from all of this, our life formed, all the life forms that are here, and the amazing thing is that we've ended up together today. All of this has happened, and we're not going to, if we pollute the waters of this Earth, we're not going to get new water asteroids coming in and saving us. And so there's an urgency now to stewarding this planet in a way which maintains the respect and the balances and just the sheer awe that we're actually here and we're all here to stay. We have to learn new ways to stay together. And I just wanted to say that's probably why all of you were born. Like, you were born into this generation and you're part of this. And I just wanted to just honor you for the work that you've got to do. And from my perspective, I'll just use what remains of my wild and precious life just to assist Indigenous laws and legal orders to take your proper place on the Earth's surface. So I really thank you very much for the time to talk to you today, and just would like to hear from you.